Hello and good evening to all of you. We are from Group D of Tutorial 8. I'm Aisyah Nadirah and I'm the leader of this group. So this is our group members. And now I pass to the next member.
Okay, thank you, Aisha. Moving on, this case touches on key aspects of contract law, family obligations, and business ethics, making it both a challenging and intriguing matter between Adam Suhaimin and Yuna. By the end of this presentation, we hope to provide clear evidence on how each party might proceed while highlighting the lessons this case offers regarding the importance of clear agreements and ethical making in both familial and business contracts. I will now pass it on to my next member.
So hello everyone, my name is Nur Fateehah and I will be presenting the first issue, which is whether Adam has the intention to create a legally binding contract with Suhaimin and Yuna, or is it just a mere agreement? The relevant authorities and cases that I took is the principle of intention to create legal relations, the principle under the case of Baird Textile Holdings Ltd against Mark and Spencer, the case of Simpkins against Pay, and the case of Snelling against John G. Snelling. So first of all, the principle of ITCLR is a requirement for a contract to be legally binding under the context of Malaysian law and the common law. So even if the other ingredients are present, such as consideration or um, capacity to contract is present, but there is no ITCLR, then the contract won't be legally binding. So next, the principle under the case of Bad Textile Holdings Ltd against Mark and Spencer, if there is no sufficient agreement on essentials, it may well reflect the absence of ITCLR. Next, the case of Simpkins against Pay involves a family-like relationship with two parties, which is Simpkins and Pay. So Simpkins live with the Pay's family. So they would regularly enter into a newspaper competition together, and they agreed that if one of them were to win, they would share the win equally. So when one of them eventually won, they refused to share the win because they said like there was no legally binding contract among them. So the court ruled that there was actually a legally binding contract because even though it's informal, the agreement became a legally binding contract because both parties would contribute the money in for entering the competition. So next, the case of Snelling against John G. Snelling, it involves three brothers who run a business together. So they agreed that if they contribute their money for the business, they won't ask for the money back. Suddenly one day, one of the brothers asked back for his money because he said that there was no legally binding contract between them because they were brothers. And the court ruled that because this involves a business context relationship, the agreement between them become legally binding. So, um, to apply sim- to apply the principle of Barrett Textile Holdings, Adam demonstrated a clear ITCLR in his agreement with both Suhaimi and Yuna by formalizing the terms of their arrangement, which differs from bad textile situation where the lack of essential reflected an absence of ITCLR. Okay, so next, to apply Simpkins against Pay in this situation, it can be seen that in both situations regarding Suhaimi and Yuna, Adam demonstrated the intention to be legally bound by firstly, similar to the case, Adam took clear actions that show his intention to create a binding contract with Suhaimin. Adam not only promised to pay RM 500,000 and provided a Ford Mustang, he also formalized his intention by signing an agreement. Adam also explicitly entered into a written agreement with Suhaimin signing on Yuna's behalf, outlining the terms for the sponsorship. These formalities and mutual commitment demonstrate Adam's intention to create a legal obligation. To relate to the case of Snelling against John G. Snelling, similarly to the Snelling case, Adam, Yuna, and Suhaimin are also family since the question mentioned that Suhaimin is their niece. Despite being family, Adam demonstrated ITCLR by signing an agreement with Suhaimin, formalizing the terms of this promise. In both cases, the agreement were intended to create a legally binding contract and affect the parties' right and not just casually family arrangement. Adam's agreement to sponsor Yuna's education in return for her working with his company for 5 years is also similar to the case of Snelling. While the agreement was between family members, Adam demonstrated ITCLR just as the brothers in Snelling had intended to create legal obligations concerning their business loan. In conclusion, it is most likely that the agreements between Adam, Suhaimin and Yuna demonstrate a clear ITCLR. Thank you very much.
I will now present the arguments from the other party side, which is Adam. In the aforementioned case of Jones v. Padawaton, it involves a case of a family relationship between a mother and daughter. It is said that the arrangement between both parties was not intended to be legally binding. It was held that there is a presumption that family members do not intend agreements between themselves to have the force of contract. Similarly to this scenario, it was mentioned in the question that Adam and Suhaimin are blood related. Therefore, in Adam's argument, it can be said that he did not have an intention to create legal relations since there were family members, and it can be considered only as a mere agreement between each other. Thus, there was no legally binding contract, and it was just a mere informal agreement between a family member. Moving on, I will now present the conclusion for both Adam and Suhaimin along with Adam and Yuna's part. In Adam and Suhaimin, if Adam's financial instability is proven to cause undue hardship, the enforcement of the promise could be further invalidated. The reclamation of the Ford Mustang could also be justified if Adam successfully argues frustration due to significant financial constraints. In summary, Adam's argument is more likely to result in a favorable judgment, rendering the promise unenforceable and allowing for the reclaiming of the Ford Mustang under the doctrine of frustration. Now moving on to Adam and Yuna. The agreement to sponsor Yuna's education in exchange for her commitment to work with Adam's company is a legally binding contract, and it was formalized and included clear mutual obligations. However, Yuna's refusal to return to work may constitute a breach of contract unless she can successfully argue frustration or that Adam's business conditions made the contract enforceable. Thank you.
My name is May Yin, and now I'm gonna be talking about the second issue, which is related to the topic of consideration. So the second issue is whether there is a valid consideration for Adam's promise of 500,000 ringgit to Suhaimin. So now moving on, let's talk about the laws and cases which can be used. So this can be seen in Section 2D of the Contract Act, where it states that when at the desire of the promiser asks the promisee to do something or not do something, or promise to do something in return, and that promise is called consideration. So on default, there must be a consideration for a contract to be valid. But however, we can see in this principle over here under common law, which is the principle of agreement without consideration under common law for pre-existing contractual duty with a third party. So in this principle is basically saying if you are already in a pre-existing duty before the promise is made, but like the promiser will benefit from the contractual duty that you already had, hence there is a good consideration. So this can also be seen in the case of Shadwell and Shadwell, where it states that the uncle promised to pay his nephew a certain sum if he is married to one Alan Nicol. The nephew at that time of the promise was already engaged to Alan Nicol, but it was held by the court that it is already a sufficient consideration as the marriage benefited the uncle. This can also be seen in the case of Scotson and Pegg, where it states that the defendant argued that there was no consideration for his promise because the plaintiff was already obligated by a contract with a third party to deliver the coal to him. However, the court ruled that the plaintiff's delivery of the coal to the defendant was valid consideration for the defendant's promise. It is valid to make a separate promise to a different party for the same action if it's benefits that party. Now, let's apply the laws and cases to the situation of the question. On default, there must be consideration for a contract to be valid, but according to this principle here under common law, it's basically saying that if you're already in a contractual duty with a third party before the promise is made, but if the promiser gets to benefit from the contractual duty that you guys already had, like the promise that he made, then there's a good consideration. So to apply it, so Adam promised Suhaimin that he will pay 500,000 ringgit to Suhaimin if he married Seri Dewin, even though they are already engaged before. So the fact that Suhaimin and Seri Devin is already engaged before prove that there's already a pre-existing contractual duty with a third party being Seri Devin. But however, Adam state that with Suhaimin and Seri Devin marriage, he gets to have the advantageous position in the competitive business field. This means that he can also benefit from their marriage as he will gain an advantage position when they married in the competitive business field. And so to apply using Shadwell and Shadwell case, as you can see here, it states that if the uncle benefited to the promise, then there's a valid consideration. And in this case, it's also similar as Adam benefited from Suhaimin and Seri Devin marriage in terms of competitive business field, like getting the advantages of the competitive business field. And even though that's already a pre-existing contractual duty between a third party, but since Adam would gain benefit from their marriage, hence there is a sufficient consideration, there is a valid consideration. The keyword here is benefit, and since Adam benefited from their marriage, hence there is a valid consideration. So now I'm going to be moving on. I'm going to be passing the floor to Simerpreet.
I will now be doing the argument from the other party, which is Adam. For Adam's perspective, there will be no valid consideration. Adam could invoke the pre-existing duty rule under contract law, arguing that Suhaimin was already bound by his own intentions and plans to marry Seri Devin. Thus, marrying Seri Devin does not constitute valid consideration, since it was a pre-existing commitment, not something done to Adam's promise. In the aforementioned case of Collins v. Godfrey, the court held that the agreement that the plaintiffs should attend court was not supported by consideration. This was because the plaintiff was under a public duty to attend court anyway, having been subopined. The law would not allow someone to recover expenses incurred in the performance of a duty that was merely obligated to do anyway by the law. Thus, Adam might emphasize that the promise was not part of a genuine bargain or reciprocal exchange. The offer of 500,000 was intended as an incentive, but there was no new act or promise by Suhaimin that was explicitly linked to the payment. Without a real exchange of obligations, the promise may not be enforceable. Now I will be doing the conclusion. There is a valid consideration for Adam's promise of 500,000 ringgit to Suhaimin as he benefited from their marriage. By applying the principle of agreement without consideration for pre-existing contractual duty with a third party being a valid consideration under common law, when they secretly got engaged before Adam's promise and Seri Devin being a third party to Adam, this principle can be applied. Adam will also benefit from their marriage when it comes to getting an advantageous position in the business competitive landscape. Hence, Adam is liable to pay the promise of 500,000 ringgit to Suhaimin. However, Adam's perspective can be argued in showing there is no valid consideration for his promise to pay 500,000 to Suhaimin. The court generally require a fresh act, promise or forbearance provided in exchange for a contractual promise to establish valid consideration. Suhaimin was already bound by his intention and plans to marry Seri Devin, irrespective of Adam's promise. This precludes the marriage from being valid consideration under Collins and Godfrey precedent. The promise of 500,000 was a gratuitous incentive without direct link to any new action or detriment undertaken by Suhaimin in exchange for the promise. Therefore, there was no genuine bargain or mutual exchange to form a binding contract. The promise of 500,000 ringgit is unenforceable due to the lack of valid consideration, since Suhaimin did not provide any new or sufficient consideration in return for Adam's promise. No binding contract exists. Adam is not legally obligated to fulfill the promise of the money at the end, since there is a principal agreement without consideration for pre-existing contractual duty with a third party, and Adam benefited from their promise. Hence, there is valid consideration. Only if there is no benefit proven, then there will be no valid consideration. Thank you.
So, moving on to the next issue, which is under the capacity of contract. So, the issue here is whether the contract entered between Yuna and Adam is considered as a valid contract. So, first, we can look into Section 2 of Age of Majority Act 1971, where it provided that the age of majority in Malaysia is 18 years old. And Section 11 of the Contract Act 1950 provided that a person who is not the age of majority is not competent to enter into the contract. This provision is supported in the case of Mahori Bibi and Darmodas Ghost. So the fact of the case is that Darmodas Ghost was a minor and he was the owner of immovable property managed by his mother. He then entered into a contract of loan where he borrowed money and mortgaged his house. The loan giver knew that he was a minor when the contract was made, and the infant's mother sought declaration that the agreement was void as he was a minor and lack of capacity. The court held that the agreement is void and not binding on the infant. And so, the general rule in Malaysia is that any contracts made by minor are void. However, there is an exception under contract for scholarship. Under Section 2 of Contracts Amendment 1976, it refers a scholarship agreement as to any contract between an authority and a scholar regarding a scholarship or any other educational support given by the authority or another person for the purpose of education. And under Section 4 of Contracts Amendment, it provides that a scholarship agreement cannot be considered as invalid just because the scholar is under the age of majority. This provision is supported in the case of University of Malaya and Lee Min Chong, where it shows that no scholarship agreement will be invalidated if the scholar entering the contract is not of the age of majority. However, under contract for necessary, the contract is not enforceable if the contract contains harsh and burdensome terms for the infants. So, according to the case of Di Francisco and Barnum, an infant entered into a contract of apprenticeship for 7 years to learn stage dancing by the plaintiff. The infant could not accept professional engagement or marry without the consent of the master under the contract. However, the contract did not require the master to provide the infant with professional dancing was unemployed. The infant later took up a professional dancing engagement with a third party. The plaintiff then sued the infant. The court held that the contract was unreasonable and could not be enforced. So, when we apply the law, Yuna was 16 years old when she entered into a scholarship agreement with Adam and is not competent to enter into a valid contract under Section 11 of the Contracts Act. Based on Mohori Bibi case, Yuna entering into a contract with Adam is considered as void because she is underage and cannot enter into a binding contract. However, there is an exception under the scholarship agreement where despite Yuna being only 16 years old at the time of entering the agreement, the scholarship contract she entered is considered as valid and enforceable. However, when we apply Di Francisco and Barnum, Yuna was required to commit to a 5-year exclusive employment contract when she was 16, which can be seen as a reasonable. However, due to Adam's company financial instability situation, it can be considered as burdensome and unfair. Therefore, Yuna has no obligation to work with Adam's company. That is all from me.
Hello, madam. My name is Nurhanis Farhana. I will be presenting the argument from Idam's side for the third issue. Firstly, Idam's contract is valid, but Yuna's refusal to fulfill her work obligation may still require her to repay Idam for scholarship expense, which are classified as necessaries for her education. Section 69 of Contract Act 1950 allows the person supplying such necessaries to be reimbursed for the property of incapable person. Idam's scholarship for Yuna qualifies as necessaries as it provided essential educations and training to improve her life prospects. Since Yuna accepted the benefits and completed her studies, she cannot retain the benefits without fulfilling her obligations under the contract. Since she breached the contract by refusing to work for 5 years after completing her studies, she is legally obligated to reimburse the scholarship expense. Next, in the case of Government of Malaysia and Guru Charan Singh and others, where in this case, the government sponsored the students to study abroad, requiring them to return and serve the government for a specific period. The defendants breached this agreement by refusing to serve, and the government sought repayment of the scholarship expenses. The court ruled that the government provided educations and the agreement was enforceable. Therefore, the defendants were obligated to repay the incurred. Chang Mintat judge ruled that an infant's liability for supplied necessities does not arise from a contract, and it is not consensus. Section 69 of Contract Act 1950, embodied by English common law, provides liability for infant to pay a reasonable sum for necessities. Thus, this contract is a quasi-contractual. Similar to the above case, Yuna benefited from a scholarship provided by Idam, which constitute necessaries. Her refusal to fulfill her work obligations allows Idam to claim repayment of the scholarship expense. So, in conclusion, the contract between Yuna, who is a minor, is valid as the contract for necessaries, including educations, are binding under Section 4 of the Contracts Amendments Act 1976. And Yuna is bound to either fulfill her contractual obligation to work for Idam's company for 5 years or reimburse the expenses incurred for her education. And Section 69 of Contract Act 1950 prevents her from unjustly enriching herself at Idam's expense, making Idam's claims against Yuna valid and enforceable under Malaysian contract law. Therefore, the contract entered by Yuna, who is a minor, is valid as the scholarship agreement is valid for minor.
Thank you, Hanis. Now moving on to the next topic, which is privity of contract. The issue is whether Yuna can take legal action towards Adam for not fulfilling his promise to Suhaimin. The law that we can apply is the common law, which stated that only persons who are parties to the contract are entitled to enforce it, meaning that no stranger to the consideration can take any advantage of a contract, although it is made for his benefit. In Malaysia, there is no specific provision according to this topic, yet Malaysia recognized the common law and apply it in the Malaysian cases. Can be applied in the cases of Tweddle and Atkinson, the plaintiff son of John Tweddle, married to the daughter of William Guy. The plaintiff's father and father-in-law have agreed with each other to pay the plaintiff $100 and $200 respectively in consideration of his intended marriage in a written agreement. The plaintiff then sued the executor of his father-in-law for the unpaid sum. The court then held that the plaintiff is not allowed to sue the executor as he is not in the consideration to the contract. The consideration must move from the party who is entitled to sue upon the contract. To apply this in the scenario, the agreement made was only between Adam and Suhaimin, which is Adam promised to purchase a Ford Mustang to Suhaimin as his wedding gift and pay 500,000 ringgit. The person who is not the parties in the contract cannot sue one of the party in the agreement as he is not the party of the agreement. So Yuna is not allowed to sue Adam for breaking the mid promise to Suhaimin, as she is not entitled to the agreement. In the contrary case, Beswick against Beswick, Old Beswick was a coal merchant. Old Beswick and his wife were both over 70 years old. He has his leg amputated and wasn't in good health. He had agreed to transfer a business to his nephew in exchange for a salary and the payment of a weekly annuity to his widow on his death. On Bestwick's death, the nephew refused to pay the annuity. The nephew then argued that Mrs. Bestwick wasn't the party of the contract, so she is not entitled to enforce the contract due to the doctrine of privity of contract. The House of Lords then held that she was not entitled to enforce the contract in her personal capacity, but as as the administrators of the estate, meaning that as her deceased husband's representative. So she was entitled to perform specific performance of the contract. As I mentioned before, it is contrary to the scenario, which means that Yuna is not entitled to involve in the contract as she is not the party of the contract. And she also cannot claim herself as the representative of her brother, as Suhaimin able to represent himself to sue Adam for breaking his promise.
So, in Yuna's argument on the other side, Adam agreed to sponsor Yuna's study in exchange for her working for his company for 5 years after graduating. So, since Yuna was a minor at that time, Suhaimin signed on Yuna's behalf, making it a legally binding contract. However, Yuna now refuses to honor the agreement, arguing that Adam's company is bankrupt. This situation changes the term significantly, unlike the case of Roberts against Gray, where a minor's contract was enforced due to its benefit. Yuna gains no advantage from working for a failing company. The bankruptcy represents a fundamental change, making it unfair to enforce the contract on her. Yuna has a strong argument that continuing with this agreement would harm her career and life forever. So that's all. Thank you.
I'm Megan, and now I'm going to be doing the overall conclusion on every issue. So for issue 1, the conclusion is the agree to sponsor Yuna's education in exchange for her commitment to work with Adam's company is a legal binding contract, as it was a formalized contract and it included a clear mutual obligation. However, Yuna's refusal to return to work may constitute a breach of contract as there is a legally binding contract. For the agreement between Adam and Suhaimin, only if Adam successfully argues his financial instability, he can claim back the Ford Mustang. But if Adam did not successfully argue his financial instability, he cannot take back the Ford Mustang as there is already a legally binding agreement when they formalize the term. So now moving on to the second issue, the promise for Adam's promise of 500,000 ringgit is a valid consideration as Adam directly benefited from the marriage of Suhaimin and Seri Dewing. So now moving on to a third issue, the contract entered by Yuna, who is a minor, is a valid contract as scholarships agreement is valid for minor. Scholarships contract are classified as necessaries as they provided significant educational and career benefit. Yuna is bound to either fulfill her contractual obligation to work for Adam's company for 5 years or reimburse the expenses incurred for education as entering into a scholarship agreement is a valid contract for minor. So for the fourth issue, Yuna cannot take legal action on behalf of Suhaimin as she is not the party to the contract restated by the principle of privity of contract.
So that's all from us. Thank you.